Hey everybody, Jake Fouts here.
And Brian Fouch.
And today we're going to welcome back Kevin Day for the second video in our security session on asset protection. And we're going to be talking about asset protection for W-2 employees. And that's something, because we probably have a lot of people out there who do have W-2 incomes. And maybe you haven't started a business yet or you're working on it, but that doesn't necessarily mean you don't need to have asset protection in place, because there still are some liabilities and some risks out there. So we wanted to make this video specifically for you guys so that you can understand what your options are available to you to make sure you have that protection in place.
Precisely. And in this segment, hopefully you listen to the introduction on asset protection, lawsuit protection. Because it'll tee up what we're doing here, because this is a little bit more strategy. It presumes that you already know how trusts work generally and why change of ownership is so important. The aspect that we're looking at here, because there are a lot of different strategies, we're just going to deal in two global ones over the next two modules. One for people that are purely W-2 estates and those that are business owners. And they're very different, as you'll see, and there's a bunch of little incremental crossovers. But the biggest thing for a W-2 employee is the liability that comes from the business isn't there. So it's just your wealth accumulation that we're really concerned with. And so where a business owner is usually going to have to own much more and therefore put more assets in the line of fire than someone who's a W-2 employee. So if we have that irrevocable, not revocable living trust, but the irrevocable lawsuit protected trusts in play, what we want to do is shift anything that is part of your lifestyle or of high value or has growth potential in your estate away from you. And so it's really a somewhat simple structure. So I'm going to take a husband and wife, and they put things into an irrevocable trust, and there are several varieties of irrevocable trusts. They're in the last module of asset protection. So we're going to have husband and wife set up a trust and name a trustee. And it can't be them. It's usually going to be...
Question for you, Kevin, because in typical W-2 employees, they're going to have, their assets might be their house. Other than that, what other things do they put in there? Is it retirement plans, vehicles? What are those things?
Good question. So retirement plans, 401ks and IRAs cannot be moved out of their personal name. You can't even put them in a revocable living trust. They're standing out there. 401ks are protected under ERISA. IRAs are not protected under ERISA. They tend to be somewhat lawsuit protected because judges, by public policy, don't want to make you a ward of the state later on by paying off a creditor. And so it would have to be a really bad lawsuit where somebody acted badly for them to invade an IRA. Homes and their savings accounts that aren't part of retirement plans is what we're talking about.
Cars.
Cars are not, because cars are rolling liability. So, oops, that's my car.
It's a
Jeep.
yeah.
And you've got your home. And then you're starting to accrue money. When you start to accrue enough money, that's when you're still a W-2 employee, but you're also starting to become a businessman or woman because you've invested that in real estate or something that you're starting to tinker with hobby-wise. This is the first thing that we have, is our home that we're starting to build equity in. And you would be most disturbed if you were kicked out in a judicial foreclosure and you have to go rent an apartment someplace. So that's the first thing that we want to protect. And then however minor the savings is, you don't want to lose that. So these are the two things that we would shift under here. Remember from the introduction of this is that this is an ultimate owner. It's separately, legally recognized as a third party, separate from any individual, and therefore if it owns the trust, as the example, if I'll recall that to you, the Kennedy grandchildren and the Carnation grandchildren that have big judgments against them are still living in nice mansions, driving nice cars because of trusts like this. If it's good for the big dogs, it's good for us. We're going to ride on those coattails. So you don't want to be the owner. And if you're technically not the owner, then these will be protected. Cars are interesting because the law allows the person that's been harmed, that got hit in the crosswalk, to sue the person that was doing the driving and the legal title holder of the car. So often a business strategy might be, oh, I can buy I can get a car's use cheaper if I have a legitimate business reason for my company to buy the car. But this is rolling liability. So we're putting liability into a business. So you have to offset the tax advantages from the asset protection advantages. And the example that we had used before, you're my best buddy from college, you need a car, I've got 4 cars, I'm going to lend you one. And you drive it for 4 years. And I never see it, I never drive it, you pay its insurance. But I'm on the DMV, it's the pink slips in my name. You get in a car accident, the law allows the person that was harmed to sue you as the driver and me because it was my car, and take money from whoever they can get it from first. So so you want to leave those out. So talk to your CPA, but usually you can get, there's other circumstances where it's good to have a vehicle in an entity, but you can usually get a driving stipend that's related to business.
Yeah, I've been there before where I was involved in a company that had vehicles for superintendents, construction superintendents.
Fleets of cars, right?
Yeah, and a couple of minor incidences where vehicles were abandoned upside down, and all of a sudden all the vehicles were now in the person's name, and they just got a monthly stipend to go buy their own vehicle.
Right.
So
right.
Essentially why they did that, I'm assuming, was they were moving the responsibility, or the potential for liability to
shifting it over
person.
to the driver, because the driver is going to be sued anyway.
Right.
Those of you that have teenage children that are going to be driving soon, it's actually, although there's all kinds of emotional reasons not to, but purely from a pragmatic asset protection point of view, it's better to put the car in their name, which would normally drive the insurance up, but you co-sign on the insurance, which will bring it back down, because if there's a car accident, my son or daughter don't own anything. Yeah.
My insurance agent didn't tell me about that.
Okay.
Probably not going to either.
Yeah, because usually it's going to be your car and you're adding them on your insurance.
Right.
You put it, depending on what you're willing to do for your kid, if they're getting the hand-me-down, Volvo, and it's worth $3,500 or whatever it is, that is cheap. I mean, the fear is, hey, my kid all of a sudden goes haywire and runs away with what I thought was my car because I put it in his name. Well, he's getting disinherited from the rest of it, so he's not going to do that. But, I mean, that's the thing, that I'm giving my kid something too early, or I'm giving him something, and that's not our family's kind of policy. They have to earn it. Well, it's saving your house. That's not only your house during your lifetime, but probably a major part of their inheritance. So it's worth getting a car in their name. You can even have them sign an option agreement that you can buy it back for $1. So if they misbehave or whatever, you can get your car back, but it's better to save your estate. So we leave the cars in your name. You're going to have an operating checking account with a little bit of money, but the house, the second house, the vacation home, if you've gotten to it, and certainly, most of us should have, certainly if you remember before the recession, we would always have a checking account and a savings account. We made 8% over here, or even more. Remember back in the 90s, you laughed at people if they weren't making 11 or 12%? It was reality at one point. It's hard to imagine now. But so let's say you were making 8% over here and you'd be making 1% over here. Now you're making negative here, maybe 1% there. But you usually have that savings account, long-term savings account, and then you replenish the checkbook every once in a while. So the checkbook is still in your name, your operating account, but the long-term savings account, your home, second homes are over here. And then when you make that first foray into rentals, it's a little bit awkward because the business strategy that we'll do in the next module is a little bit different, but we can add a separate LLC to distance that renter from your home and accounts by having a little LLC here.
And that LLC is within the trust.
It's owned by the trust, so it would be owned 100% by the trust, just like these are owned by the trust. And I don't like to overstructure, but there are reasons not to hold these two properties directly in the trust, although you can. So you might have two LLCs here. One is for your home and cash, and one for the first rental property or two. If you get more than two or three, then you might want to start with a different type of strategy. But what our job is to analyze where you are, what assets are valuable, or even if they're not that valuable, but they're your lifestyle. You might have a home that has very little equity in it, but you chose that home for a reason. It's in the right place, it's the right school district, you like the trees that are on the property, you like what you've done to it for the last 4 years, and even though there's only $30,000 worth of equity in it, and the bank owns most of it, a judicial foreclosure costs about $8,000. Somebody's just sued you for 2 years and they haven't gotten their money yet. They will kick somebody out of their house for $12,000 of equity. So you don't have to have a lot of equity in your home for somebody to ask the court to run a judicial foreclosure. So it's actually, I don't want to belittle it, but it's a really simple strategy. You decide what's liability or should be in your name, and what's your lifestyle or what's valuable, and put it into an irrevocable trust.
Yeah. You know, the first time I did a trust, I was a W-2 employee at that point in time. This was obviously years ago now, and I believe mine was an irrevocable, not irrevocable, but I remember it was an hour and a half sit down after I filled out some questionnaire stuff.
Mm-hmm.
That was all it took to set that up, and
Right.
I really haven't looked back at it since.
Right.
So definitely a very easy something to set up, and if you haven't done it yet, I'd always recommend it. I always recommend it to people when I meet them, just because of the liability reasons and protection.
Mm-hmm. Exactly.
And I think the important part is these plans are going to be different for whomever's involved, whether you're W-2 or like you're going to see in the next video for business owners. So, I mean, that's why we work with people like Kevin, because you're going to see lots of writing on here and it may look confusing, but when you call, Kevin on the phone, they walk through exactly what you're supposed to do. Like Brian said, that process is actually fairly easy. So I just want to kind of make sure that everybody knows that. And so if you want to contact Kevin, you have the stuff below, like Brian said, underneath the video to reach out and make contact with him. And this video was for W-2 employees, so we'll see you guys in the next one where we kind of take it to a different level and work with people who are business owners. So,
Excellent.
all right, thanks.